Okay.
SJC-11073, Commonwealth versus Butler.
Thank you.
Hey, can I have two? Thanks.
Good morning. May it please the court?
Hold on, please.
I'm
One
sorry.
moment. We want to get you on record. Okay, let's proceed.
May it please the court? My name is Michael Fellows. I represent Reginald Butler in this matter. It's our position that Mr. Butler's right under the Article 11 and the Sixth Amendment to the Constitution to a speedy trial attached on September 16, 1991, when a criminal complaint issued out of the Chelsea District Court. It's further our position that in January of 1993, when Mr. Butler, who was at MCI Concord at the time, signed a form that was sent to the Chelsea District Court requesting a speedy disposition of his case, asserted his right as he was required to under Barker v. Wingo. In 1998, the Commonwealth dismissed the charges. In the meantime, of course, nothing happened. In 1998, the Commonwealth dismissed the charges, and it's our position that at that point, the speedy trial clock is tolled until May of 1999, when the superseding indictment comes down. At that point, the speedy trial clock begins to run again.
So it's stop and
Those
restart.
reasons,
Stop and restart.
essentially, that yes, that there's the period in between the dismissal and re-indictment is not counted under the Sixth Amendment.
And when do you say that the clock originally started? Is that on March 11th of 1998 when the defendant was arrested and arraigned?
No, on September 16th, 1991, when a criminal complaint issued out of the Chelsea District Court. For those reasons, it's our position that Justice Hinkle, I believe, did the motion to dismiss prior to trial in 2000, was in error in denying the defendant's motion to dismiss for violation of his right to a speedy trial, and that therefore his appellate counsel, prior appellate counsel, was ineffective in not raising that issue in his first appeal.
If you're wrong about when the clock starts, if it is really when the indictment and arrest take place in, is that 1998?
1999.
1999, right, 1999. Do you have a speedy trial issue if it's 99 to the time of trial in 2003?
Frankly, I don't think so, and that's not the argument that I'm making. I mean,
So a lot of it hinges on whether or not you're correct
all
as
of
to when
I believe, hinges on whether I'm correct as to whether the speedy trial clock is tolled or whether it's reset.
No, I mean, when it, if you're not right about when it starts in the first instance, that is to say, did it start upon the issuance of the district court complaint in 1991, or did it start in 1999 with the indictment and arrest?
Well, yes, but I guess there are two issues going on there. At least the Commonwealth has argued that a criminal complaint doesn't trigger the speedy trial clock.
Well, I suppose if he'd been arrested at that point, maybe it would have been different.
Well, the
Commonwealth's
cases that
argument.
I've read, and I would cite to Malone, to Commonwealth v. Gove, Willis, all of those cases say in Massachusetts that the speedy trial clock for Sixth Amendment and Article 11 purposes is triggered by the issuance of a criminal complaint. Malone, the issuance of the criminal complaint goes back to 1980, and the court says that's when the speedy trial clock is triggered. Now, however, the Commonwealth didn't find him until 1993, so the court held that they weren't responsible for that time between 1980 and 1993.
Yeah. Does it, when you say that it starts on the issuance of a complaint, but is that based on case law in which the complaint issued upon the arrest of the defendant?
In Malone, no, he was not arrested because he was not around.
And it didn't count?
In Gove, well,
The time didn't count.
The plain language that the court says is that the speedy trial right attached at the time the criminal complaint issued. Now, they ended up finding that there was only 9 years or 7 years of delay because they didn't know where the defendant was. In this case, the Commonwealth knew where the defendant was the entire time.
And he, unlike
Could have known.
presumably Malone, he knew of the complaint because he had, I mean, he knew that the detainer had been lodged on account of it, which is
Yes.
why he filed the thing that he filed.
Yes.
In
And
93.
he requested a speedy trial.
Right.
I would say, I don't believe that the arrest, I believe the speedy trial clock is initiated at the moment the criminal complaint enters. But if it requires an arrest as well, then the moment that the warrant was, the detainer was filed at MCI Concord, I would argue is the equivalent of an arrest. The police aren't going to go into the prison and arrest him. That is the equivalent of an arrest. So at the latest, then, you could say 1992 is when this the speedy trial clock started.
Now, if you're right, let's assume you're right with regard to the tolling provision. As far as I can tell, all that gets you is probably a finding that the length of the delay was presumptively prejudicial.
Yes.
And then it gets you then to the four-part analysis.
Yes.
Okay. Now, what is the consequence of the fact that when there was the appeal, the appeals court did do an evaluation under Rule 36C of the Mass Rules of Criminal Procedure, where they looked at whether the prosecutor was unreasonably lacking in diligence in bringing the defendant to trial, and whether there was prejudice to the defendant, which is two of the four prongs of analysis under Barker, and said you lose under 36C. I mean, hasn't he gotten some semblance of the four-part analysis already in the appeals
No,
court?
Your Honor, I would say he hasn't, because the Barker-Wingo standards are very different than 36C. First of all, 36C says, and in the case, the Butler case from 2006, the court says that he has to demonstrate that the prosecutor intentionally was engaged in behavior that caused this delay.
I don't think so under 36C. I think that's a due process analysis, not a 36C analysis.
Well, it does say that it's the prosecutor who has to be at fault.
Right.
In Barker v. Wingo and others, or we could look at U.S. v. Doggett, under the Sixth Amendment, it doesn't have to specifically be the prosecutor who causes the problem. Court congestion cases are out there where the Sixth Amendment protects your right to a speedy trial just because the courts are crowded. It's not the defendant's fault. He has a constitutional right to a speedy trial. He doesn't have a 36C right to a speedy trial. And in U.S. v. Doggett, you have a defendant who, as far as I can tell, the U.S. attorney never knew anything about the investigation that was going on in the case. A complaint issued. The ATF lost him. He went to another country. He came back through customs. Customs didn't notice that he had come back, and he's living in the country openly for 6 or 7 years before the ATF runs credit checks on people with warrants and immediately finds out where he is and goes and gets him and arrests him. And the Supreme Court said that this was a violation of the Sixth Amendment right to a speedy trial, not because the prosecutor caused the delay, but because the government caused the delay. The right belongs to the defendant. And it's the government as a whole, including the courts, and there are many cases that say the courts and the prosecutor have a duty to bring the defendant to trial. I would suggest it also that means it extends to the clerk's office. If there was an error in this case that for some reason caused the Commonwealth not to be able to see that this case, that the speedy trial motion had been filed, that blame has to lie with the government. Although I find it exceedingly unlikely to believe that the Commonwealth has no basis, no way to find out when warrants are outstanding, when criminal cases are sitting in the district court, not moving anywhere, that nobody ever checks. But in this case, apparently, nobody ever checked.
It is
The
curious.
other part,
Maybe I misunderstand the facts here, but he was released from prison, correct?
he was.
So this detainer
And 3
apparently had no effect.
Well, what happened was he filed the motion for speedy trial, and then the the motion judge made findings of this, something happened where somebody was misinformed in the prison. And what happened was he would get these summary key issue sheets that he would sign that would tell him about his
Outstanding.
progress through the system. And in 1993, there were 3 separate charges out of Suffolk Court, out of Chelsea, and I think out of Cambridge that he had to take care of. He filed speedy trial petitions in all 3 of them. By March of 1994, it said no legal issues. So as far as he understood, and apparently as far as the prison understood, these things had been taken care of.
Was there an issue having to do with some misinformation on the docket in some of his requests?
The one number, now these, and this, the findings of fact say that the prison typed up this form. All he did was sign it. One number in the docket is incorrect in one place. It says 9113 when it should say 9114.
It's got his name and everything on it.
It has his name on it. It says Chelsea District Court. The 9113 is simply the court number. It just indicates what the court is. So clearly the Chelsea District Court couldn't have been confused about whether this was in the right place.
Oh, it wasn't a docket number.
It was the docket number, but the first 4 numbers of a
yeah,
district
is
court
the
docket
court
number
number.
is the court number.
Okay.
And that was the number that was wrong.
And the correct number is also on there.
And is also on the form, yes. The other reasons that Barker-Wingo is different than 36C, well, there are 2 reasons. First, under 36C, the defendant has a duty to press his case through the court system. Under Barker-Wingo, the defendant has a right to a speedy trial, and he has to assert his right. He has a responsibility to do that. In this case, he did so. And once he did so, he was informed that he had no further legal issues. The Commonwealth argues that he should have followed up on that after he was informed by the prison that he had no further legal issues, and that by not doing so, he somehow has waived his right to a speedy trial. Now, under 36C, you might be able to make that argument, but under Barker-Wingo, I think that argument has to fail, because again, you can't waive a constitutional right by not pushing hard enough, by not, he should be able to expect that the prison is giving him correct information and rely on that information. I would note that my brother has pointed out that there's a form. I included all of the forms that I got from the prison in the submissions I made to the court, thinking that I might be cross-examining or examining a prison official. Some of those forms, I don't believe the defendant ever saw. He certainly never signed them. But there is one form where it's a classification report, and somebody has written wrong person, and then drawn an arrow towards some of the charges on the left. It's not clear to me that in fact, I don't believe Mr. Butler ever saw that form. And I'm not sure even if he did, he would know what it meant, because if you look at it, it's not clear whether it's pointing to the Chelsea District Court case or to the Suffolk armed robbery case, or what he would make of that. But what we do know is after that, he was told he had no further issues, and he relied on that. The final part of the Barker-Wingo standard that is much different than 36C is prejudice. In cases of this length, when the speedy trial, when the delay is this long, the Supreme Court in the United States v. Doggett created a doctrine of presumed prejudice. Essentially, what happens at this point then is that the defendant doesn't have to show how he was prejudiced, because as the court says, it's often impossible to do so. The Commonwealth, or the government, now has a duty to prove, beyond a reasonable doubt, according to Commonwealth v. Malone, that the defendant's ability to defend himself was not impaired. And I would say that that's a much different, first of all, it puts the burden on the Commonwealth, not the defendant, and they have to show that his defense wasn't impaired. And in this case, all of the examples of prejudice that the court said the defendant really couldn't show caused harm to his case, lost cushions where the rape allegedly occurred, lost photographs, lost pages from a rape kit, missing witnesses, a witness who may have died, and multiple instances of faulty memory. All of those things show, I think beyond a doubt, that his defense, or certainly prevents the Commonwealth from saying, we can prove beyond a reasonable doubt that his defense was not impaired. How can you cross-examine witnesses who have no memory? How can you examine witnesses who are dead, who aren't there? We have no idea what the extent of the prejudice was in this case, which is why Doggett is the appropriate standard to use.
Well, a judge suggested here that the loss of memory, to the extent that there was loss of memory, it inured to the benefit of the defendant. What do you say about that?
Well, I say again, the Commonwealth, I don't think that it's possible to say that it inured to the defendant. I think that it is possible to say that it caused problems for the whole trial, for both sides. But the Commonwealth has to demonstrate and make a positive demonstration that it did not impair the defendant's, that this time lapse didn't impair the defendant's case at all. And that I don't think that they have done.
Sir, your time is up.
Thank you very much.
Thank you.
May it please the Court, Joseph Ditkoff for the Commonwealth of Massachusetts.
Mr. Ditkoff, put aside for a moment the two different docket numbers on the request for a speedy disposition.
Sure, Your Honor.
Put aside that. Why shouldn't we conclude that the clock starts to run at the filing of the complaint, or certainly no later than the warrant was lodged at the institution and he filed a request for a speedy disposition?
Well, Your Honor, and first of all, I want to point out that this is an ineffective assistance of counsel case.
I understand that.
But the reason why, if one would have this res novo, it doesn't apply, is twofold. First, there is considerable case law that says that a complaint to support an arrest warrant doesn't start the constitutional speedy trial clock at all. And the reason why that is so, if you look at the purposes of the constitutional speedy trial right that the U.S. Supreme Court said in Loud Hawk, minimize the possibility of lengthy incarceration prior to trial, reduce the lesser but nevertheless substantial impairment of liberty imposed on an accused while released on bail, and shorten the disruption of life caused by arrest in the presence of unresolved criminal charges. None of those apply in an unexecuted arrest warrant situation.
All right, well, let's assume for a minute. Well, first of all, the detainer is lodged, the warrant is lodged, so presumably, apparently it didn't have any effect here, but presumably it acts as a restraint on his liberty because he won't be released while the warrant is lodged, right?
It shouldn't be.
Shouldn't be.
I don't think so, because the detainer by itself, detainer of an arrest warrant, was only a warrant detainer. If you look in the defendant's appendix, actually my appendix as well has it, wasn't the complaint that was lodged. Doesn't bind the Department of Corrections. They can decide to honor it or not. What's important to note, if you look at the docket sheet of the district court, which is in my brother's appendix, you'll see that this warrant was never lodged in I shouldn't say never, was not lodged in warrant management until 1997, until after the defendant had been released. So it wasn't there as a lodged warrant that if you check to see if this guy's got a warrant, if he gets stopped, if you're about to release him, that you would run into.
All right, and I don't know how that works. Whose fault is that? It was certainly lodged at the prison.
As the Chelsea police officer.
Okay. Let's assume for a moment that this was not a complaint for crimes over which the district court did not have ultimate jurisdiction. Let's assume it was a larceny complaint.
Yes, Your Honor.
Different analysis?
Certainly a different analysis. I still don't think a arrest warrant complaint controls, because you ask yourself, why does an indictment start the constitutional speedy trial right, period? And of course, the text of the amendment says, in criminal prosecutions, ... right to speedy trial. And with an indictment, and Doggett, by the way, there was no complaint. That was an indictment case. That's why it started. An indictment, grand juries voted, that doesn't start a case. A prosecutor signs an indictment, walks up to the judge and says, here, I'm filing this indictment. That starts a case. So I don't think the issuance of a complaint in a district court jurisdiction case starts the constitutional speedy trial clock. But when it comes into court at the summons date, where the defendant either shows up and gets arraigned, or a default warrant issues, which is the first point at which the prosecutor knows about the case, assuming we're not talking about a prosecutor application for complaint, that's when the clock starts, because a prosecution has started at that point.
Well, now, Mr. Fellows said that I think Malone was the case, that in fact it was just the complaint being issued. And they didn't know where he didn't come into court to get arraigned because they didn't know where he was.
That is correct. In the Malone, I litigated the Malone case,
Okay.
so I know it pretty well. There was a complaint to support an arrest warrant in 1980, and the Malone case, the court said that the right started then, but they didn't actually. Then the very next paragraph, they say, well, it starts in 1993, which is when the defendant was located, and the prosecutor actually sent investigators to talk.
So they say one paragraph it started in 1980, and the next paragraph it started in 1993, and we get to choose? Is that what you're saying? I haven't read the opinions.
I think it's a confusing opinion. We won that opinion, so there was no way to ask for FAR. But it doesn't matter at all what Malone says, because Malone came out after Attorney Mazza filed the brief on a direct appeal here. So he couldn't use the teachings of Malone to tell him what he was going to do, what was a sensible thing to raise on direct appeal.
So you think there's been a change in the law? Is that what you're saying?
No, I think the Malone case is impossible to figure out what it means, and you can't really follow it. That's what I think about Malone. But
I guess I guess in part I'm wondering this: if Attorney Mazza had a view of this that was wrong, maybe not manifestly unreasonable, but plain wrong, this defendant gets no right, gets no relief because it's ineffective assistance of counsel? Is that what you're saying?
yes, Your Honor, the Maher case, the Walker case, attorneys who were wrong. The standard is, first, did it fall below the standard of an ordinary fallible attorney? And second, was there prejudice? And if you don't have both of those, you don't have ineffective assistance of counsel. In the Maher case, the attorney said, let's go to trial, let's reject the plea agreement because we're going to win on the meaning of entry. And this court said, no, that's not what entry means. But there was no ineffective assistance because that was reasonable advice. The Walker case, a defendant says, we can't win on appeal. The attorney says, we can't win on appeal. And it turns out he's wrong about that as far as on the search and seizure thing, and it doesn't matter because it's an ineffective assistance of counsel issue. Even the Lau case that my brother relies on, Justice Spina said at page 225, we analyze whether the failure of defense appellate counsel to raise a Crawford issue fell measurably below the conduct that might be expected from an ordinary fallible lawyer, just the standard Safarian standard. And it's important to note, if you look at note 3 of the Lau case, that this court said it was not going to consider the Gonzalez case because, and that's a case that came out after the defendant filed his brief. They would consider Crawford because that had come out before the defendant filed his brief. And so that is how it works. Unless this being, we know, unlike in the Lau case, this was a tactical decision. We have an affidavit and a finding by the motion judge that this was a tactical decision by Attorney Mazza. And so for the first prong, it becomes whether it was manifestly unreasonable. That's why your first appeal does matter. This isn't just a dry run for a second appeal where if you find an issue that in hindsight or with new case law, you can now win the case, you get to go as if nothing ever happened if you hadn't tried your first appeal.
But it was a tactical decision based on his view that he could not in good faith make the argument. And isn't that just plainly wrong?
Is it wrong that you couldn't make it in good faith? No, I agree that's not the case. But it was also his view that that was not a winner. I mean, that's what he thought. And that was a very reasonable view to have because there are 3 very high hurdles he would have had to climb over that I don't even think he can get over now.
But isn't that a somewhat different analysis? I mean, I understand that, but it generally doesn't cost one anything to throw in a constitutional speedy trial act above and beyond the Rule 36 argument. He chose not to because he thought he could not in good faith do so. And haven't we found that when their arguments are essentially costless, and you, for whatever reason, think that you may not bring them, that you're ineffective for failing to bring them, and you may lose on the grounds that you would not have prevailed, but don't we at least consider whether or not that argument would have prevailed?
There's a few questions you asked me, Your Honor. certainly we consider how strong the argument is. That's what we're doing here, among other things. But it's certainly not costless. I put my Attorney Mazza's argument section in my appendix. You see it already goes to 46 pages. And this is not something that you can, in any useful way, throw out in a page or two. You see how much complication there is on when does the right start, does the complaint start the right, does the good faith dismissal reset the clock. There's a lot of things to be analyzed there. So it's not costless. He would have had to have either dropped an argument or, more likely, given less at his 36C argument, which I think was his strongest argument. So it's not costless. And, of course, just in general in appellate advocacy, you don't stick the needle in the haystack. If you've got your needle, you put your needle out. You don't want to bury it in other issues that are not as strong as that issue. I mean, the advantage he had with the 36C issue was, at least as we litigated it, if he could convince the court that there was prejudice, he won. I mean, that's how I litigated it. That's what I conceded. Now, the appeals court, the first panel, rejected my concession of negligence before the first appeals court panel. But at least as we were litigating it, if he could prove prejudice, he just won. Nothing about when it attached or whether the dismissal reset it. That was all he was going to have to do. And that's what kept me up awake before that oral argument, was that issue. And he's looking at that, where all he has to do is show that, versus a situation where he has to get over first the hurdle of does the dismissal reset, where he's got Burton against him, he's got McDonald against him. Now, I admit in a footnote that was not the issue of McDonald, so I don't think it controls. But if you look at page 11 of the McDonald Supreme Court case, when the Supreme Court of McDonald decides whether the right was violated, they consider only the time after the civilian indictment and none of the time between the original arrest and the dismissal. And, of course, we have the Ninth Circuit, not considered a government-friendly circuit, Fourth Circuit, Tenth Circuit, now Kansas, Maryland back then. And there was case law to the other, but there was a lot of case law to get over. Then when you take the arrest warrant complaint issue, you had this First Circuit opinion in Rashid versus Walsh saying that doesn't work. You also have the Ninth Circuit, the Seventh Circuit, the Fourth Circuit, California, Illinois, and really nothing going the other way except for the states that say an arrest warrant by itself initiates the constitutional speedy trial right. And even that case, which I cited, Rayburn versus Scully, if you look at that case, they don't actually apply against the government any time prior to when the government got involved with seeking to extradite the defendant. None of the time before that actually gets applied against the defendant. I also found a very old Florida case that went the same way that I don't know. I didn't bother to find out whether it was still good law. And so those two giant hurdles he has to get over, but he has to get over a third hurdle, which is the question of whether any of the delay can be chargeable to the prosecution before the prosecution knows or has any way of knowing that this case exists at all.
Well, in Doggett, that happens, right?
Absolutely not, Your Honor. In Doggett, the clock starts with the indictment. And my brother's theory that the U.S. attorney didn't know about the indictment that he signed is impossible. And in fact,
So all the subsequent stuff is after the, I remembered it was the same process, yeah.
Yeah, everything that's considered in Doggett is after the indictment. And what's considered, of course, is the government's investigators making no serious effort. Now, the Supreme Court capitalizes government because they don't like writing the United States as investigators. But these are all investigators that work with and for the prosecutor. And so that's why it applies. If our investigators or the police officers that are assigned to us had been negligent, then that would be on us. But a Chelsea police officer who never communicates with us, doesn't even put in warrant management, though that would not be enough for us to know about the case.
So I hope this all doesn't turn on. You're suggesting this all turns on who authorized the arrest warrant as to whether the speedy trial clock starts?
Oh.
So if the Attorney General's office had authorized the arrest warrant, it starts at the issuance of the arrest warrant or the complaint?
No, Your Honor, I'm on the third hurdle. The first hurdle and the second hurdle,
All right.
I don't believe it does. But even if you say that it starts. The second Barker versus Wingo factor is reasons for delay, and the Commonwealth has no knowledge of this until 1998. That's another huge hurdle for the defendant to get over. And it simply isn't the case on defendant's assertion that 36C requires any assertion by the defendant. It only requires negligence on the part of the Commonwealth and prejudice to the defendant, unlike Barker v. Wingo, which does require a defendant's assertion. And in fact, Barker v. Wingo itself, the defendant lost solely because he had nothing on the third prong.
One of the things the defendant is suggesting, I think, is that, well, maybe the courts are partly to blame here, like as in Chelsea. What if the clerk or some clerk, assistant clerk, whatever, in the Chelsea District Court had entered something in the docket saying, look, we've received this, and brought it to a judge's attention? What should have happened?
Well, the motion came on a case that had never been arraigned, but you'd think it should have been certainly entered into the docket. And I mean, I don't know what they do today. What would be advisable would be to bring it to the attention of the court, of a judge, and to the prosecutor.
And presumably make arrangements for an arraignment.
Well, once the prosecutor knows about it, we would have done something. And if we hadn't, it would be entirely on us. But yes, I can't disagree that, one, the Chelsea Police Department should have done more, and two, the clerk's office should have handled this. Because even though there is an error in the thing that the defendant filed, it wasn't an insurmountable error. You could certainly figure out which case it went to.
What is your position on the prejudice that Mr. Fellows, the argument on prejudice that Mr. Fellows makes, I mean, if one gets there?
Oh, well, now we're at the advantage that we are past the actual prosecution, so we know what happened at the trial. We know that the witnesses, except for Joseph Bradley, who wasn't a precipient witness, had quite good memory. The victim had very good memory of what happened. We know the defendant exploited the time delay by saying, first arguing the time delay itself, and obtaining a lesser sentence for that, and in fact arguing that this makes her unreliable, the victim's testimony unreliable. And as far as the cushions, I mean, if we had affirmatively proved the cushions don't affect him, well, we have DNA evidence from a vaginal swab, so I don't think the cushions make any difference. The deadlock, the damage to the door was described by almost every witness and killed our burglary thing because the victim's description of it, which was the same description she had right at the beginning, was just inconsistent with what everyone else said. And the rape kit, the only thing that was lost from the rape kit was the victim's statements, if there were statements back then from the rape kit, but we still had what she told the doctor in the medical records, same thing, I was raped. So I think it's pretty clear that that doesn't stand. And as far as missing witnesses, there didn't seem to be any missing witnesses. There was no witness the defendant said that he wanted or was looking for. Remember, he was pro se for most of the trial. So if we had to do that, I think the appeals court's finding that there was no prejudice here, trial prejudice, is very solid.
All right, thank you very much, sir.
All right.